some of the debris was removed, okay? We're going to go to photograph 101. And just describe that if you could for the record.
Again, it's the torso we found, however, all the branches have been removed from the top of it.
Okay. Was that the position it was in after all the branches were removed?
Yes.
Okay. And I think you testified previously that the limbs were severed and the head. Couple different views.
These photos the jury is looking at right now are absolutely horrific, as you can imagine. We're going to squeeze in a break. We'll get you back for more testimony right after this. Welcome back to Court TV Live. I'm Julie Grant. Thank you kindly for spending part of your Thursday with us. Just want to give you a little reminder before we head back into the parents' dismembered trial in Wisconsin. Court TV has a policy of never showing graphic photographs. And right now, the jury is looking at some of the most sickening, disgusting images you could think of. The detective detailing finding that human torso. And right now, they're looking at photos of the torso. Very upsetting photographs. We are going to go in live, but you're not going to see any of that. So just wanted to let you know, if you're seeing the seal in the courtroom, that is why. Of course, the court would not want the public seeing those, and of course, Court TV would not do that in any event. So that is what is happening in this case. I believe we're going to go back into the courtroom, if I'm correct, and there is the detective on the stand. His name is Brent Baverstock. He's with the Dane County Sheriff's Department.
The deterioration of the torso. Were there insects and things of that sort around?
Well, typically we'll call in a forensic entomologist, but it's part of the decomposition process when any animal or any living tissue is exposed to the elements. Flies will come, they'll lay their eggs. Within a certain amount of time, those eggs will hatch into maggots, and the maggots will feed and begin to consume and continue on with the process of breaking down the body.
Okay. We're coming to an end, but fair to say that while you may have been the first one to come upon this, a lot of people ultimately descended on this farm and got involved in the investigation at that point.
Yes.
Okay. And in fact, we're probably going to hear from you again in this case, aren't we?
Probably, I would think so.
Okay. I have no further questions for now for the detective.
Cross-examination.
Nothing for now, thank you.
May the witness be excused but not released.
Yes.
Thank you so much. Detective, thank you. Have a good remainder of your day.
Sure.
Attorney Brown?
I think it would be a fair place to break for lunch.
I think we can do that. Ladies and gentlemen, it's a little early, but I always think that it's either better to be well before noon or afternoon. But I don't know what your plans will be. It is almost 11:20, and let's plan on being back at about 12:45.
You heard the judge there. The jury's going to be taking their break in this case, going to be heading out to lunch. Perfect time for me to be talking with our guest, who is standing by in Denver, Colorado. Criminal defense attorney Jeffrey Wolf is on the program today. Jeffrey, good to see you this afternoon. Thank you for lending us some of your time today to watch this unbelievable trial. You think you've seen it all in criminal court, just come to work tomorrow. That's what one of my great uncles used to say. That was a sheriff's deputy a long time ago. And I want to talk to you about what this sheriff's deputy was saying on the stand. We know he's a detective in Dane County, and he talked about going to that property. And as I was watching him, he was you could see the change in his face and hear the change in his voice when he was talking about what was underneath that pile of sticks. Share with us your reactions to that, the way in which he conveyed it to the jury, and just being someone who practices criminal defense work, what effect, does investigative work like this have on an investigator like that one in Dane County?
Yeah, I thought he did a really, really good job of conveying to the jury that this was not normal, that this was not part of his everyday job. Because anybody that works in the criminal justice system on either side of it, whether it's a prosecutor or a detective, investigator, or on the defense side, there are certain things you just don't see every day. And we do see a lot of things that would make most people skin crawl on a daily basis. But something you don't see every day is a dismembered body. And body parts out in the open, decomposing. It's just not something you see every day. And so what a the effect of the detective having a personal affect from that is that it lets the jury know the gravity of the situation, that they're seeing something unusual, a little bit more in the prosecution's mind depraved here, and I think it conveys the severity and the seriousness of the offense to the jury to have it actually affect the detective. And I don't think he was play acting, because like I said, this is not something that anybody sees regularly, much less a rural Wisconsin investigator like him. And so this is unusual. It is a little bit more graphic and gruesome than most cases would be. And I think he did a pretty good job of conveying that emotion to the jury.
So well said, Jeffrey. I completely agree with you. And we touched on this a little bit the other day on the show. I was saying, if you've ever had an abuse of a corpse case, it is something you will never forget, whether you're a prosecutor, criminal defense attorney, investigator, or even just a member of the court staff, when you have to see that evidence and look through it and think about the Herculean effort. I mean, and it is a Herculean effort to dismember a body and then scatter the body parts around, as is alleged in the facts of this case. And then when you think about these officers who have a task of going to work and not knowing what they might encounter, it might be drafting an affidavit, interrogating a suspect, or stumbling upon a human torso. You're right, he really impressed upon the jury the gravity of that scene, that crime scene. Tell me about the challenges you see, when you have a crime scene, things are scattered in this case. It all isn't contained to one place. It may have started at the home, but then, as we know, it extended beyond the home. And for investigators to piece that all together, talk to us about practically how many hours and all the manpower it takes to even do that and solve a case like this.
Oh, the manpower hours are almost incalculable because they're going to be different every single time, right? And that's one of the reasons that a defendant would do such a thing if he in fact did this, right? Is you would want to make it harder to investigate, harder to solve, harder to piece together. But the problem is, in modern forensics, it doesn't matter. They're able to put things together much quicker than they used to be. They're able to take a small piece of evidence and get a larger picture out of it, even if they don't find the entire picture. And so it's an immense amount of work for detectives to put together something like this. And then it's an immense amount of work for the prosecutor to sort out everything they did. And an even larger piece of the puzzle is the defense team trying to make heads or tails of what they're looking at when they get this. Anytime you get a case that involves a large amount of forensics and a huge investigation, that means that there are going to be hours and hours and hours of just video of what they did, if they're wearing body cams like they should be. Additionally, you're looking at thousands of pages of police reports, thousands of pages of medical records, thousands of pages of autopsy records, photographs. The amount of data that gets generated by an investigation like this is incalculable. It's impossible to know what you're going to look at when you open that file.
Well said, Jeffrey. And when this prosecution team is estimating this trial could go a couple weeks, you believe it, don't you, right? Knowing the sheer volume of evidentiary matter they have to show this jury.
Right, even with the defense not questioning almost all of the witnesses, especially extensively. They're not really questioning anybody. But there is so much for the prosecution to lay out that, yeah, this trial could go on that long with the defense not putting up much of a fight on a lot of this evidence, because to them, it's not what they need to be focused on. Obviously, this stuff was found. Obviously, it's there. None of it necessarily points to the certainty of the guilt of their client. And so they're not taking a bunch of the jury's time, but the prosecution doesn't have much of a choice. They have to get this all in front of the jury.
Jeffrey, talk to us, please, about what the defense is doing here. You are a criminal defense attorney. You're in and out of courtroom day in and day out, courtrooms day in and day out, and trying various cases. Here, we're seeing a defense on innocence grounds. And I'm curious if you think this is the best approach for Chandler Halderson's legal team to be taking on a case like this one.
So it's hard to know what the best approach is in any case just by watching the trial. because there's so much that goes into it. There's meetings with the client. There's evidence that maybe isn't going to the jury. There's evidence that hasn't been presented yet. There's questions that haven't been asked yet, right? But as of right now, what we're seeing is something that you often have to do in a case with tons of witnesses is you have to be surgical about the questions you ask, because the jury is waiting on bated breath for everything the defense does in response. And sometimes it can send a very, very clear signal to them to don't pay attention to the man behind the curtain if you don't ask a question of a witness, because what they just said has nothing to do with whether your client committed this crime or not. They are testifying about a gruesome amount of violence depicted on a body. But if your client didn't do that, what questions do you have to ask about that body? None.
Jeffrey Wolf, thank you so much for all of that. So much more we want to discuss with you here on the program today. It's getting to that time. We need to squeeze in a break, though. When we come back, we'll talk about a motions hearing, a big one that was had in the case of the Doomsday couple. It took place on Wednesday. And the issue is trying to silence Laurie Dabell. What? And her former attorney from speaking to the public. Why? We're going to break it all down for you next here on Court TV Live. Welcome back to Court TV Live. I'm Julie Grant. We want to turn our attention to the case of the Doomsday couple, Chad and Laurie Dabell. Got some big developments happening on Wednesday. So prosecutors in the case asked the court to restrict both Laurie Vallow and her former attorney, Mark Means, from speaking to the public about the case, after Means filed some motions publicly discussing some confidential information. And during the hearing, the state asked to have certain restrictions clarified as well as extended. Take a look.
And the state recognizes some of the state shared in those same concerns and had raised a lot of them in response to some motions filed by Mr. Means. But specifically what the state is referencing or looking at is the concern regarding Mr. Means filing documents under penalty of perjury and documents that specifically referenced or at least alluded to conversations he may have had or did have with his client, Ms. Dabell. The state has concerns, shares the court's concerns regarding those and the potential for Mr. Means to become a witness in the case. So we would ask the court to consider looking at Rule 1.9, and the court had previously referenced 1.7 in the court's prior order, whether or not some kind of an additional order prohibiting or restricting disclosure of any conversations he may have had with Ms. Dabell and or discussion of the most recent pleadings that had been filed where that was referenced. The state believes it may be prudent for the court to look at entering some kind of an additional order. We wanted to raise that concern and leave it in the discretion of the court. The state does not believe anything has changed with regard to the protective order and the need for the protective order or the potential negative ramifications and implications if that order is lifted with regard to Mr. Means.
Let me ask a question here, Ms. Blake. The protective order, in effect, relates specifically to documents in discovery and information in the case. I guess the concern I have is what's being raised here. To me, seems like you're asking for what I would consider a gag order, where in your motion is requesting that I order that he be prevented from public comment, for example, and as you just mentioned, from essentially talking about the case, which to me, that's a request for a gag order, which is certainly different than the order that's in effect that only relates to discovery in the case. So is the state asking for a gag order here?
We are not, Your Honor, and I guess I should be clear on that, and maybe I'll clarify that a little bit better. We are asking that the court clarify whether or not the current protective order that has been granted specifically is currently in place with regard to Mr. Means that is applicable under Rule 16L. We're asking for clarification that that remain in effect. If the court did not see it as remaining in effect right now, we would be asking to expand or extend that order to continue to remain in place with regard specifically to Mr. Means based on the attached declaration that was filed with the state's motion and the rationale provided in there. And then so that was kind of a two-part argument. And then the third part, and I think I called it a two-part argument, but the third part would be the state just wanted to essentially address our concerns and join in the concerns addressed by this court in the most recent order regarding those communications. We are not specifically asking for a gag order. We wanted to raise the concerns that the state had and then leave it in discretion of the court whether or not any kind of an additional order is appropriate. I think in our motion, we'd also specifically outlined the state is not asking for a gag order, generally speaking, because we have indicated in our motion, and it would be our position, that we do think if at any point the court ordered or the court authorized Mr. Means to talk about any of the discovery materials under the protective order that was put in place under Rule 16L, and or if the court did create any other kind of an order restricting Mr. Means' comment regarding conversations he's had with his client, that would still be in the court's discretion to allow those comments to occur. The state is not trying to become the micromanager of those. We just had concerns and felt it was more appropriate if the court and or current counsel, Mr. Archibald, if one or both of your permission were required for any kind of disclosure regarding the discovery materials, and then separately, if the court does enter any additional order regarding restriction of conversations, that then the authorization be required from the court and or Mr. Archibald for those to be made public or for public comment to be made regarding those matters.
Okay, well, thanks for your clarification on that point.
So ultimately, this is what happened. The judge slightly modified that protective order, basically saying that the attorneys on the case can share discovery materials with anyone needed to assist them, but not with the general public. And that protective order applies to Valu's former attorney, Mark Means, as well. But you heard the clarification. The state wasn't asking for a gag order, so no such thing was issued with respect to any of the attorneys on the matter or Mark Means, who is no longer on the case, because previously it was determined by the court that there was a conflict of interest with Mark Means because the court found that he had represented Chad Dabell, Laurie's husband, before he represented Laurie and before Chad was formally charged. And so the court found that that was an unwaivable conflict, meaning one that Laurie Vallow can't have a say-so and say, I waive this and I'm okay with it and it's fine. Legally, the court found that that would just be unethical and improper and against the rules. So Mark Means is going to be off the case. Let me bring in someone to weigh in on this crazy case. We have criminal defense attorney Jeffrey Wolf standing by in Denver, Colorado. Jeffrey, is it just me or is this such a mess? What did you think as you were listening to that, please?
I thought that it's like almost every other small town in America trying to try a big case. There's so much incestuous work in between these things. We've seen the animosity between this attorney Means and the prosecution. And now we find out that he represented the husband prior to representing the wife. I mean, the whole thing is always so convoluted when you're in a small town. It's one of the reasons that a lot of times people want to bring somebody in from out of town, which doesn't always, elicit the big dragon coming in from the big city into the small town that they think it will. But what it can do a lot of times is eliminate some of these issues. It can give a fresh face to a case that doesn't have history with the prosecution, with the judge, and with co-defendants and witnesses and everything else. Because I worked in a small town when I was a public defender, and my clients would routinely tell me that the judge would take care of them because he knows their mama. They would routinely tell me that, and he routinely would. Small towns are just different. They just are, and that's what we're seeing here. And, it seems like the prosecution's argument in this case is as clear as mud. They want everything, but they don't want to ask for any of it directly, is what I'm getting from them, and what the judge seemed to be getting from them as well. I think that the ethical guidelines on attorneys control all of this stuff, though. I don't think any of it is necessary, quite frankly, because you can't
Jeffrey.
reveal what your clients
Yes,
tell you.
you can't reveal confidences.
Yeah.
Thank you. Bravo.
Yeah, you can't reveal what your clients tell you to anyone, much less the media. You
Right.
can't talk about what's in discovery if
Got to
it's not
go.
for
I'm
the
being
case.
told we have like 10 seconds. We'll keep
No
talking,
problem.
but you hit the nail on the head in your quote about what they want is as clear as mud. It was the best thing I've heard all day. Jeffrey Wolf, thank you. We will be right back. You are watching Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant, and it's great to have you along with us on this Thursday afternoon. We are live in the state of Wisconsin in day number 3 of testimony in the case of the young man accused of murdering his mother and father. But there is more. The allegation is that he then dismembered their bodies and scattered their remains. 23-year-old Chandler Halderson is facing criminal charges in the killings and dismemberments of his parents, Bart and Krista. Their body parts were scattered and then later discovered across Dane County, Wisconsin, days after they were reported missing. Now, prosecutors claim that Halderson killed his parents to cover up a web of lies that he was telling them, as well as others in his family, like his girlfriend and friends, covering up the idea that he was a student and that he had job opportunities, and none of that was true. He was playing video games all day. We heard more testimony this morning from some people who knew the defendant very well. Court TV legal correspondent Chanley Painter is live outside of the courthouse with the details for us. Chanley, good afternoon.
Hey, good afternoon, Julie. What a morning it has been inside that courtroom. The jury starting to hear testimony from the prosecution's case revolving around how the detectives and the investigators were able to unravel those web of lies you just mentioned that this defendant allegedly told after his parents went missing last July. And they started with those he knew best almost, his girlfriend's mother and his mother's girlfriend, the remote farm they lived on here in Dane County, Wisconsin. First, this jury heard from his girlfriend's mother, Dolce